Jain. He is the advocate of the 5 women petitioners. Vishnu Jain, really appreciate your time. It's a big step forward, certainly, for the 5 women petitioners of yours. The district court clearly said that it's not about ownership, but it's about right to pray. But will your petitioners stop at just seeking the right to pray, or will the petition eventually change and look at challenging the overall religious character of the Gyanvapi Mosque?
See, very good evening, Maria, and I'm so happy to be there on your show. The point in issue is, and let me tell you that there are 6 suits which are pending before the Varanasi Civil Court, and this is just one of the suits. The other 5 suits are filed with the relief of title. So we are claiming title over the property in question, and this suit is for right to worship. The point in issue is that in this particular suit, the commission was ordered, and now the report of the commission is there. And as per Order 4 Rule A, Order 4A of the CPC, all these suits have to be clubbed together and tried together. And when that will happen, the report of the commission will be read in all the suits. So it is not just right of worship. There is a title relief also which is pending in other 5 suits which have been admitted. Notices have been issued, and the Masjid committee has still not filed their reply. So that's the whole long and short of the matter. And so far as this particular issue is concerned, let me tell you that in this case the Places of Worship Act was not attracted. We had argued it for a long time before the civil judge as well as before the district judge, Honorable Mr. Justice A.K. Visheshwar. And the fact of the matter is that in this case the Waqf Act is also not attracted. So all these are the points and the legal arguments which we made before the court, and therefore the application under Order 7 Rule 11 has been rejected. And now in future the commission report objections are already invited from the Masjid committee on the commission report, and if they don't file that, the commission report will become final and it will be read into evidence, and in future other evidences also will be led in this matter.
Okay, given the nature of evidence collected so far, Vishnu Jain, will you seek scientific survey of the evidences?
See, definitely as per Section 45 of the Indian Evidence Act, a scientific survey is required to establish our claim, and I had already moved a petition before the Honorable Supreme Court seeking carbon dating of the Shivlingam which has been found. The Honorable Supreme Court was pleased to direct me to file my application before the trial court. Now those applications will be filed. Apart from that, apart from scientific survey, the artificial walls of the Shivlingam which has been found beneath the Wazu area has to be demolished to see the arga of the Shivlingam, and therefore other further ASI surveys and other scientific demands will be made in the future.
Okay, since you're saying that this is just a beginning here, you will be challenging the entire nature of this structure as well. You are talking about the title suit as well. Help us understand, Vishnu Jain, because you are clearly saying that the Places of Worship Act 1991 doesn't apply here, neither does the Waqf Property Act apply. Talking specifically about Places of Worship Act 1991, should that be repealed because there is already a petition pending in the Supreme Court?
See, Places of Worship Act, we have challenged the constitutional validity, and it's a dream situation when Places of Worship Act will be repealed. That's a separate issue which will be debated and argued before the Supreme Court on 11th of October before a 3-judge bench. Now the point in issue is this, that within the framework of Places of Worship Act we have argued and we have made the Honorable Court to reject the application under Order 7 Rule 11, and the argument is precisely this, that under Section 4 Subclause 1 of the Places of Worship Act, the religious character of the property in question has to be determined, which was existing on 15th August 1947, and therefore on 15th August 1947 we have categorical pleading in our plaint that this property in question was having all the characteristics of a Hindu temple, and before 15th August 1947 also it was having all the characteristics of Hindu temple. And let me tell you that till November 1993 Vyas ji used to do puja in the so-called Tehkana beneath the mosque, and on the western side of the mosque till November 1993 all the women devotees and all the devotees used to worship Ma Shringar Gauri every day till November 1993. It is only in November 1993 Vyas ji has been ousted from his position from the Tehkana, and the puja of Ma Shringar Gauri has been restricted only to one day in a year. So the point in issue is that which kind of masjid can exist in this country where on the western wall the puja is happening from time immemorial on the western side of the mosque, and beneath the mosque Vyasji is doing puja, and in the center of the mosque where Wazu is there, Shivlingam has been found. And I am not saying, Maria, that whatever I am saying is the final authority and the final verdict. Lot of work has to be done in the future. The scientific evidence has to be led. If one side is claiming it's a fountain, if the other side is saying it's a Shivlingam, it has to be gone into by an independent agency, by an expert agency, and all those evidences has to be led and brought on the record before the Honorable Court, and then only the final verdict will be there. But today, let me tell you what the Muslim side and the Masjid committee is trying to say. They are saying that if we have said it's a fountain, please reject their petition under Order 7, Rule 11. We need not go further into this question. Against that approach, I have an objection, because if there is a dispute, this dispute in a democratic setup has to be resolved by courts of law. This dispute cannot be decided by the parliament. This dispute cannot be decided on the streets. In a democracy and in a democratic setup and a civilized society, all these disputes can be decided peacefully in a court of law. And the Muslim side was given ample hearing. Masjid committee was given ample hearing to make their point before the Honorable Court, and after hearing them, this order has been passed.
Okay, my final question to you. Since you're talking about the Masjid committee, the Anjuman Intizamiya Masjid committee have already moved the Allahabad High Court. What next for you?
See, we will definitely file our caveat before the Allahabad High Court. We will request the Allahabad High Court not to grant any stay in this matter, because this is an issue where the trial has to go on. We will ask for day-to-day trial of the matter. We will ask fast-track courts to be constituted, and this matter should be referred to a fast-track court, and day-to-day trial should happen. And ultimately, the point is that all these disputed questions of fact, places of worship act attracted or not, whether this property is waqf or not, it has to be gone into and looked into by cogent evidence, and that's what precisely the Honorable Court has ruled today.
All right, Vishnu Jain, really appreciate your time. Thank you so much. Let me bring in other